If you have been served with a temporary restraining order and a court date to appear for a future hearing for a final restraining order, you do have several rights. First, you have the right to an attorney to defend you. Second, you have the right to provide documentary evidence that proves your innocence to any of the allegations made in the temporary restraining order. You have the right also to seek a short continuance, meaning asking the court for additional time to have the final restraining order hearing so that you can obtain counsel or gather your proofs. It's important for you to hire a competent attorney to represent you, as having a restraining order entered against you can result in several consequences, such as loss of income or employment, the obligation to participate in certain classes such as anger management or parenting classes. Temporary custody can be awarded to the filing party. You can be prevented from enjoying parenting time during the proceedings. If you have a final restraining order granted against you, you'll be unable to have a firearm in the state of New Jersey, and the restraining order will last for an indefinite period of time. The only way that restraining order will be dissolved is by further order of the court, which would probably require another hearing. It can be a very taxing and emotionally challenging time. However, if you appear in court without an attorney, the judge will still impose all of the same requirements against you. If the evidence that you bring is not in proper form, you'll be unable to use it to defend yourself. It's important for you to give us a call today at Next Chapter Family Law so we can discuss how to protect you from having a final restraining order entered against you. Common errors that I often see certain clients making, usually before they retain me, is having third parties communicate with the other party that is filing the complaint. Third-party communications can be deemed and are often deemed as a violation of a temporary restraining order before the judge. And you may be held in contempt, which is a criminal charge and can affect your criminal record, even if that final restraining order isn't actually entered. Also, common mistakes are not being prepared enough to defend yourself, not having certain things such as text messages, bringing witnesses that can't testify as to what's contained in what's called the four corners of the temporary restraining order. You can't bring people just to testify generally about your character. Character evidence is typically not permitted in courts. People, such as witnesses, can only testify usually about what they directly observed. So it's not having proper witnesses, it's not having the documents in proper form, it's not having enough documents. It's using third parties to contact the party that's filing a restraining order, which can trigger a criminal contempt charge. It's speaking to another protected party, such as a child, just because he's your child. If he's listed in the temporary restraining order, you're in violation if you communicate with that child. All of these factors can make the situation worse, so it's best to contact an attorney. We're here at Next Chapter Family Law to walk you through the process. Having a restraining order entered against you can be highly adverse to your custody and employment rights. For example, if a child is part of that protective order, you can be prevented from exercising parenting time until some requirement is fulfilled that is established by the court. For example, you might be required to only visit your child supervised, and that can be through a third-party neutral person or at a family visitation center, which can be uncomfortable for many. Additionally, some employment can be affected if you have a restraining order entered against you, especially if you work in situations where children are present, schooling or daycare centers. Essentially, New Jersey is an at-will state, so if your employer becomes aware that you have this restraining order entered against you, they can take legal action and terminate your employment, especially if they believe, children might be at risk, if that's the sort of job that you do. Additionally, if you're required to carry a firearm for your job, a final restraining order being entered against you can cost you your employment because you'll be unable to carry a firearm. For example, if you're a security officer or a police officer. Additionally, a court will evaluate the existence of a restraining order if child custody is later evaluated as part of a divorce proceeding. A judge might look at a restraining order very negatively and award you less parenting time than you otherwise would have likely been entitled to. And that can affect your child support requirements negatively, because the less time that you physically spend with your child or that child sleeps over at your house, the more child support you'll likely have to pay. If you've had a restraining order entered against you or is currently pending against you, or you have any questions regarding how this can affect any child custody arrangements or support obligations, please contact us at Next Chapter Family Law. We're here and we're happy to answer any questions that you may have.